Hi, I'm Mark Cantor. Thank you for visiting us at cantorandberger.com. I want to talk to you for a moment about definitions in workers' compensation. There's a lot of confusion out there about what these words mean, and insurance companies hire lawyers that throw out this terminology in an effort to confuse you and pay you as little money as possible. When lawyers do that, it upsets me, particularly if they're the claimant's lawyer. You got to explain to your people what these things mean. And so that's what I'm going to do here. If you're not represented and these words are being thrown at you, this will help you, but you probably need representation because workers' compensation is a specialized area of law. It's controlled by administrative law judges that only hear workers' compensation claims. And you need to get these things right and understand how the law works and what these definitions mean in order to win your case. So I'm going to talk to you about some of those today. All right, so you're injured in Missouri. Do you win your case? You got to have an employer. You think that you work for someone, but you may not have workers' compensation benefits unless that person is defined as an employer under the statute. An employer in Missouri has 5 or more employees. There are exceptions to that, for instance, construction workers. But basically, an employer has to have 5 or more employees. You can't be an independent contractor. Independent contractors are not covered by Missouri workers' compensation, and there's a lot of tests to decide whether or not you are an independent contractor or you were an employee. So you have to look at that first. A lot of times taxi cab drivers, for instance, are considered independent contractors and not employees, and then therefore when they're involved in an accident, they're not covered. Since workers' compensation is a creature of statute, there are certain forms that need to be filed. These forms are not complicated, but they've given them complicated names. For instance, a Form 21, well, that's simply your claim for compensation. So Form 21 is a claim for compensation. Before that is the notice requirement. There's a lot of ways you can give notice of your injury. For instance, you can tell your supervisor. You could write it down. You know, hey Joe, I was injured lifting. Put the time and date. But the employer likes to have a workers' compensation Form 1, and this is just one I got in today, which is a report of injury. So that's the promulgated Form 1 for the notice, although you're not required technically to use this notice. So you've got the notice, the claim, which is the Form 21, and there's other promulgated forms, like for temporary total disability, when you get your benefits and when you don't, that they like to use the workers' compensation forms. We have all of those here at Cantor and Berger. They're also online, but when you come to us to represent you, we have all those things necessary. The first is a report of injury, a Form 21. Is a formal claim for compensation. The report of injury, sometimes they call it an ROI, just gives the name of the claimant, the time and the date of the injury, and the details of the injury. There is a reporting requirement in Missouri that you give notice within 30 days of a compensable claim. All right, so you filed your notice and you filed your claim with a lawyer. The notice acts as a claim, by the way, if you don't file a formal report, if you don't file a Form 21, a formal claim for compensation. Your report of injury gives you 2 years, 3 if no report of injury is filed from the date of your injury to file a formal claim for compensation. But once you've done those things, the employer is obliged or required by law to file an answer. So you're going to receive an answer, and it's probably going to say that they admit you were employed, but they deny all the other elements of your claim. What does that mean? Not much. That's a technical legal answer. So if you fell off a bridge and broke your legs, they would admit your employment. They may deny that you sustained an accident. They may admit that you sustained an accident, but state that they've provided you all the treatment necessary. So don't get upset by what the answer says because it doesn't mean a whole lot. It's a technical legal response. Authorized treating physician. The authorized treating physician is the doctor that the company chooses. Doesn't mean anything other than that's the guy they have to pay. And that's the person that's going to say you have little or no disability. So after you're injured and you're wanting to receive your temporary and total disability, or TTD, there's something called a waiting period. What is the waiting period? The waiting period in Missouri is defined under Missouri Revised Statute 287.160. And basically what the waiting period says is that if you miss less than a few days, they don't owe you. So if you miss 3 days, forget about it. Once you miss 2 weeks, they need to go back and pay you the TTD for the first 3 days. So it's not until you're out for 14 days that they owe you the first 3 days that you've missed, and they only owe you 2/3. And once you are injured, you're entitled to, while you're off work, something called TTD. That means temporary total disability. So TTD is the money you get when you're off work, and it's basically 2/3 of your average weekly wage up to the maximum amount. And the temporary total disability is defined under 287.170 of the RSMO. That simply means the revised statutes for the state of Missouri. So 287.170 tells you how much you must be paid and how it is calculated. There's also something called TPD, which is temporary partial disability. And that's if you're unable to work completely, but you can work some. And TPD is defined under 287.180 of the revised Missouri statutes. When calculating temporary total disability or permanent and partial disability, the lawyer should refer to the SAWW. Those letters mean state average weekly wage, and the state average weekly wage is promulgated by the state of Missouri, and your temporary total disability benefits are 2/3 of the state average weekly wage up to a maximum amount, and your permanent and partial disability are 2/3 up to a maximum amount. So for instance, if you were injured in June of 2013, the state average weekly wage maximum amount for temporary total disability under 287.120 would be $827.75, and for permanent partial disability would be $433.58. And actually they use the state average weekly wage in calculating the benefits owed to a surviving spouse, even in a civil case. So SAWW means state average weekly wage. Here's a big one. MMI, maximum medical improvement. That's the term that the authorized doctor for the insurance company is going to throw out so that they no longer have to pay you temporary total disability. Once you're at MMI, you're as good as you're going to get. Maximum medical improvement, that's a magic word, term of art, that the insurance companies want the authorized treating physician to use so they don't have to pay anymore. It means you're done treating. I frequently find that my clients who are told are at maximum medical improvement by the authorized doctor, which is the insurance company doctor, still need another surgery. They need pain management. They need psychiatric counseling. They need a lot of things. They're not at as good as they're going to get or at this maximum medical improvement. They've got a long road still to go. It's a hardship. Well, that's a word that I like. because that's what a good lawyer will file for you to say, hey, my client's not at MMI. They're entitled to TTD. They're not yet ready for PPD, permanent partial disability. They should still be receiving the temporary total disability, the weekly pay, until they get as good as they're going to get and actually do reach MMI, maximum medical improvement. The lump sum that you're entitled to at the conclusion of a case is called permanent partial disability, or PPD. And I'm looking to my right because I have the computer screen up. Permanent partial disability is defined as under 287-190, and we're going to go over here and take a look at that real quick. So you can Google RSMO, which is the revised statutes for Missouri. You can type in, for instance, any of the statutes I just said, 287-190, and you double click, and there it is for permanent partial disability. In addition to temporary total disability, which is the time that you're off from work, you are to be paid based on the schedule of losses. I call that the meat chart. And if you'll come back to me for a moment, the Division of Workers' Compensation gives you out these charts, and this is how you calculate permanent and partial disability. To give you an example, the shoulders were 232 weeks, the wrist is 175, the knee is 160, the body as a whole is 400, and I have other videos that talk about these different body parts. But that's what permanent and partial disability is. It's a way for the employer and the big insurance companies to pay you, but not pay you too much for an injury. It doesn't pay any money for pain and suffering. And I can go on and on about how that's unfair to the claimant and why you need a good lawyer, but PPD is permanent and partial disability. It's for your actual disability. CSR, that is the Code of State Regulations. That's where you find, it's like an addendum to the law, certain additional things, like the reporting requirement, the requirement that an employer file an answer in a timely manner, things of that nature. 287.240 deals with death benefits in the state of Missouri. If you're killed or a loved one is killed as a result of a work injury, the death benefits are terrible. For instance, the employer is only required to pay $5,000 for burial expense. If you do not have any financial dependents, you're unmarried and there's no one dependent upon you for support, that's all they owe. My feeling is that that is ridiculous. If you do have a dependent, your dependent would be, if it's a minor child, they would get benefits until they're age 18 at 2/3 of your average weekly wage. Your spouse, your wife to a husband that died, or a husband to a wife that died, would receive 2/3 until they died, unless they remarry, in which case they get a 2-year lump sum payment, and then the obligation to pay death benefits is exhausted. You should also know that because the death benefits are so weak, that you need a lawyer to look at and see whether there's a civil cause of action. And in this firm, we frequently handle death cases both in workers' compensation as well as a civil cause of action, and it's not double dipping. You're not getting more money than you deserve, trust me. These cases always end up, in my opinion, unfair to the family of the deceased. So we do everything we can to maximize the recovery, and you'll see that by calling us, you'll see that we're knowledgeable about those things. What is SIF? SIF is the Second Injury Fund. August 28, 2013, the last legislative session of Missouri basically abrogated the Second Injury Fund. If you have not filed a claim before January 1, 2014, you do not have a Second Injury Fund case. If this firm is representing you and you were eligible for a second injury fund claim, you have one. Cantor & Berger does not accept second injury fund only cases now, as the fund is not well funded and you only receive a small amount of money for your disability. So what is the 287.223? That's the new fund, and it's for mesothelioma risk management fund. And that basically says that if you have mesothelioma as a result of occupational exposure, there's monies that you can recover in Missouri, and we'd be happy to talk to you about those type of claims because there is a fund for mesothelioma. In order to maximize your recovery, your lawyer needs to have the threat of trial. That's not a mild or casual threat. That's, we've done all the depositions, we've spent all the money and done all the work, and the trial is tomorrow or next week or a month. It's not, 6 months before when there's no pressure. Then either the case will be tried and you'll get a judgment, an award. It's called an award in workers' compensation from the trial administrative law judge. Or maybe, if your lawyer's done a good job, you can enter into a settlement. The settlement is called a stipulation for compromise settlement. A lot of times they're referred to as stipulations. What it simply says is the amounts that are agreed upon to pay you in order to resolve the case. In order for a stipulation to be valid, it needs to be signed by the other attorney, by you, by me as your attorney, and by the judge. Even if there's an offer, nothing is done in workers' compensation. It's not like a contract or any other type of law that you may be familiar with. In workers' compensation, it's not a done deal until the stipulation for compromise settlement is approved by the court. Then they have 30 days to pay you. So a stipulation for compromise settlement is simply the document that resolves your case. And lastly, and this is a little bit tongue-in-cheek or sarcastic, I want to talk to you about a trial lawyer. A trial lawyer is a lawyer that goes to trial. It's a lawyer that knows how to handle these cases, whether it's a civil case or a workers' compensation case. It's not the threat of trial. It's not that you filed a claim. It's that you know how to go to trial. You don't just advertise. And we present these videos because we know this off the top of our head. When you look at some of the videos of Gary Berger, or some of the videos of myself, we're telling you these things because we know them, because we try these cases. So if you want a trial lawyer, find a lawyer that tries cases and not just advertise. Call us at 314-542-9999 and don't let these insurance companies cheat you. The law already puts you at a disadvantage. You need a trial lawyer to win your case. I'm Mark Cantor. Thank you for watching.